To the second case on this morning's docket. It's case number 105-918, 105-919, State of Kansas v. Smith Parker.
May it please the court. Samuel Shire of the Appellate Defender Office, appearing on behalf of the defendant appellant, Willie Smith Parker. Your Honor, may I please reserve 4 minutes of rebuttal argument?
4 minutes is granted.
Thank you, Your Honor. I do intend to address the issues raised in the brief in the order in which they were briefed as time permits, with the exception of issue 2, the aiding and abetting alternative means issue, which I intend to submit on the brief. Certainly, if this court does have concerns that I'm not addressing through argument, please do redirect my argument. Moving to issue 1, this is a sufficiency of the evidence issue. So this court's standard of review is one in which it reviews all trial evidence in the light most favorable to the state, and then determines whether the jury could find proof beyond a reasonable doubt as to each essential element of the state's charge. At issue in this case is whether the state has proven premeditation in a first-degree murder prosecution. To premeditate, a person must think about doing something before they do it. This case presents strong evidence that somebody intentionally killed Alfred Mack, but there is no evidence from the record that that killing was done with premeditation. The evidence at trial tended to suggest that 3 individuals, possibly including Mr. Smith Parker, burglarized a residence that Mr. Mack lived in. The evidence also demonstrates that a single gunshot was fired, hitting Mr. Mack in the chest. At the time, Mr. Mack was sitting in a chair, possibly sleeping or watching television.
So we have at least 2 factors that we've listed can point to premeditation: the use of a gun and no sign of provocation by the victim.
Yes, sure. Well, I believe one of those factors is present, Your Honor. Obviously, there was a use of a deadly weapon, which freestanding does not establish premeditation. As to the lack of provocation, I would not agree that that factor is demonstrated by this case. There was no apparent struggle prior to the time that Mr. Mack was shot. I believe the evidence demonstrated that. But that does not necessarily equate to a lack of provocation. For all the jury knew, for all this court knows, Mr. Mack may have done something to startle a burglar slightly before his death. Perhaps indicate that he was intending to call for help. Really, it could be a number of things. There was simply no evidence admitted during this trial.
My recollection was that the shots were fired from the doorway.
Yes, Your Honor, that's what the evidence tended to indicate. But I would say again that there simply was no evidence at what Mr. Mack would have done when apparently his door was kicked in. If he indicated that he was intending to cry for help, then that could provoke a burglar to make a sudden decision to fire a shot in his direction.
If the testimony was that the perpetrator or perpetrators kicked the door down and shot the victim as he was rising from the chair, which I think was the testimony or the possibility was testified to, that doesn't give a reasonable inference of intentional premeditated shooting, murder. I mean,
Your Honor,
a juror could reasonably infer where we are, right?
Your Honor, I believe that may be the case if there was evidence that there was no provocation whatsoever, that immediately upon breaking into the door, a shot was instantaneously fired. However, it may be the case, based on trial evidence, that Mr. Mack did something to provoke this gunshot. And since there really is no evidence...
That would be a good defense, but the state doesn't have to disprove any potential defenses. It has to prove that the facts are such from which a rational jury could infer the elements of the crime.
Yes, Your Honor, but the state also has the burden of proof in this case, and really, we're not talking about the inability to prove a defense. We're talking about a situation in which there is a total vacuum of evidence about what happened immediately prior to Mr. Mack's death. And I think in that vacuum of evidence, a jury is not allowed to speculate or guess as to what did or did not happen. I think also problematic to the state's premeditated first-degree murder conviction is that based on trial evidence, there would be no way for the jury to determine beyond reasonable doubt who the shooter in this case was. The state's theory was that 3 individuals broke into the apartment, assuming that one of those individuals did premeditate and decide to kill Mr. Mack. There's no evidence that would tend to indicate the other 2 shared that same intent. And for that reason, the first-degree premeditated murder conviction, I don't believe can stand for 2 distinct reasons. Moving to the third issue, that would be the consolidation issue. I believe that reversal of all convictions in this case are required because the state consolidated 2 cases which had really nothing to do with each other, aside from the fact that evidence established that perhaps the same gun was used in each crime. This court's standard of review is one in which it reviews all the findings of the district court for substantial competent evidence. This court does review de novo whether, as a matter of law, one of the 3 statutory conditions permitting for consolidation were present in this case. And I believe, as a matter of law, none of those conditions were present. Those 3 factors are whether the crimes charged in separate cases are of a similar character, whether the crimes charged are of the same act or transaction, and also, number 3, whether the crimes are part of a continuing scheme or plan. In this particular case, obviously, these 2 offenses were not part of the same act or same transaction. They were also not of the same general character. These were both homicide offenses. However, just because a statute is similar in type in the abstract does not mean that those offenses, as presented in a particular case, are similar in character. In these particular cases, the 2 types of homicide offenses were really about as different as one could imagine. On the one hand, the district court had a case in which it believed that Mr. Smith Parker had burglarized a residence for financial benefit and in the process killed one of the residents. In the other case, we have a theory in which the state believed that Mr. Smith Parker was angry at one of his friends for an incident of domestic violence and essentially killed his friend due to a personal grudge.
Now, it wasn't just a friend, was it? It was the co-defendant or the co-burglar?
Co-defendant, Your Honor. Well, would have been a co-defendant.
Well, alleged to have committed the, or been with him or committed the shooting of Mr. Mack, correct?
Yes, Your Honor. And if
then there was testimony that following that, Mr. Letourneau had some different behavior in the days following that first homicide?
Yes, Your Honor, there was testimony to that effect. However, I mean, these 2 cases really were so connected in time by pure happenstance. There was nothing that connected these 2 cases, even by the state's theory of the case.
Well, what connected them is the 2 committed the crime together at which a homicide occurred, and then a few days later they have a dispute between them in which one shoots the other.
If that dispute in any way related to the earlier homicide, then the cases would be part of a similar scheme or plan, I suppose. But the evidence was really pretty unambiguous that the dispute had absolutely nothing to do with the earlier homicide. Under the state's theory of the case, this homicide, this Letourneau homicide, was supposedly committed because Mr. Smith Parker was angry about an incident of domestic violence that Mr. Letourneau had committed. That was the motive for that killing. And I believe also important in this consolidation issue is the fact that the two defenses presented at trial had absolutely nothing in common with each other. On the one hand, in the Alfred Mack murder case, Mr. Smith Parker's defense was that he simply wasn't there. It was a general denial of criminal involvement. In the Letourneau case, Mr. Smith Parker's defense was that this was an accident, that Mr. Letourneau was acting suicidal near the time of his death, that he had pointed a handgun toward his head, and that Mr. Smith Parker batted that gun away. The gun unfortunately fired, resulting in Mr. Letourneau's death. These two types of defenses really are about as far apart as one could imagine. And that's why the error in this case in consolidating these cases was so prejudicial, and really very similar to the type of prejudice that occurs in a typical 64-55 case. The jury was allowed to use evidence that Mr. Smith Parker may have been engaged in a homicide in the past to infer that Mr. Smith Parker did not accidentally cause a gun to discharge, but rather that he did so on purpose. And for that reason, I don't believe that this court can find the errors in this case to be harmless. Moving to the confrontation issue, I believe that the district court's Crawford ruling in this case was obviously incorrect. Unless this court has questions about the actual ruling, I would move straight ahead to the reversibility of the error. And the statement that was attempted to be introduced by defense counsel was that Mr. Letourneau said that his girlfriend, quote, would never have to see him again shortly before the time of his death. Again, the defense in this case was that Mr. Letourneau was acting strange, possibly suicidal, shortly before the time of his death, and that he had indicated that he would possibly shoot himself by pointing a gun toward his head.
What was the other evidence supporting the idea that Letourneau was suicidal? There was other evidence about that, wasn't there?
Besides that statement, Your Honor, there was obviously the testimony of Mr. Smith Parker. Mr. Smith Parker did not believe Mr. Letourneau was suicidal, but he did testify that Mr. Letourneau was pointing the gun at his head. Additionally, there were some...
His testimony was, in essence, he was just screwing around, right?
His testimony was that he was just screwing around with the gun and pointing it toward his head. Obviously, a jury could take that testimony and reach a different conclusion than Mr. Smith Parker did.
Wasn't there another witness who also said, I think it was Letourneau's significant other, that his behavior had changed radically in the previous week?
I believe that witness testified that his behavior was strange and odd. I don't believe it went much beyond just commenting that Mr. Letourneau was acting strangely.
Okay.
Wasn't there a comment that could have implied suicidal thoughts? Didn't she say he said something strange about you and the kids the kid won't have to worry about me, or something along those lines?
That was the statement that was excluded from evidence, Your Honor.
Okay.
And I believe that's exactly why this ruling was so prejudicial.
I'm sorry, yeah.
But she was permitted to testify that he said something that led her to believe he was leaving her, or made her afraid that he was leaving her, or something like that.
She did testify that she believed their relationship would be over. And apparently that's how she interpreted the statement, not as a comment on his suicidal nature, but rather that their relationship was over. However, a jury could certainly hear that information, coupled with the fact that there was testimony that he was holding a gun to his head, and reach a different conclusion. Just very briefly touching on issue 5, the district court in this case instructed that if the state had proven its first-degree murder case beyond a reasonable doubt, that the jury, quote, will enter a verdict of guilty. I believe that is contrary to state law. There is no statute that requires a jury to enter a finding of guilt if the state has proven its case beyond a reasonable doubt. The only thing by statute that a jury is required to do is acquit a defendant if the state has not proven its case beyond a reasonable doubt. So for that reason, well, in Kansas, jury nullification is always a possibility. And for that reason, I believe that the district court's instruction was error. And then just very briefly, touching on the last issues, or the last trial issues raised in the briefs, I would just note what I think is important in the district court's ruling on not recalling the jury is the letter that was actually submitted to the district court. The reason cited by the presiding juror that the dismissed juror needed to be dismissed was that he did not understand English well enough to understand very simple terms.
And there was evidence from which the judge could find that was credible, that evidence being what happened in voir dire?
Yes, Your Honor, although if this court, well, there was that testimony in voir dire.
So are you saying that notwithstanding what the judge knew about this juror that they were complaining about, that he did in fact admit that English was not his first language, that he thought he'd be able to handle it, but wanted to let the court know? Are you saying that the court should have nevertheless done further investigations upon being advised that the language problem that was brought up before the impaneling had manifested itself, that nevertheless the judge should have done something more?
The judge should have done something more, Your Honor. The judge should have recalled the jury. And if this court actually reads the statements that were made during the voir dire, it does not demonstrate a potential juror that has difficulty with the English language, aside from his statements that he did. If this court looks at his actual communications, the juror spoke English very fluently. And again, what I think is important about the letter is that it demonstrates somebody who is not only able to communicate in English, but is able to communicate in English very, very proficiently. This was a very well-written letter. This was not the type of letter that could be written by someone unless they had a firm understanding of the English language, and that's exactly what should have prompted the district court to take further inquiry and to recall the jury.
But wasn't the juror's comment to the court that the juror had difficulty sometimes understanding things that were spoken, especially if the person was a rapid speaker? And so aren't we focused not so much on whether that person is able to write or speak the language themselves, but whether they're able to assimilate the information that's being spoken to them? I think many people that study foreign languages would tell you that those are different skills as you're learning a language.
Well, Your Honor, I don't believe that there was any accusation made by the presiding juror that the removed juror in this case did not understand the trial evidence. The statement made by the presiding juror was that the removed juror did not understand the jury instructions submitted by the district court, did not understand the very simple words that were used in those instructions. And the letter that the removed juror wrote to the district court would tend to indicate otherwise.
But there was also a statement that the other jurors were having trouble relaying for him to understand what they were trying to say about those explanations as they tried to explain those definitions, if I recall.
I believe, and I would defer to what was ever written in the presiding juror's affidavit. I think that was just disagreement over whether they needed additional clarification of the instructions. And further, these are two affidavits. The district court, I don't believe, was in a position to say, well, this affidavit is truthful and this one clearly isn't. I think the district court needed to recall the jury basically so that it could reach a reasonable factual determination.
Do we have any more questions of counsel? Thank you.
May it please the court, Christina Trocek appearing on behalf of the appellee state of Kansas in this matter. Starting with the first issue, that being whether there was sufficient evidence for a reasonable juror to find the defendant guilty of premeditated first-degree murder. The state's position with this issue is that there were at least two inferences of premeditation the jury could have considered in this case. There was the use of the deadly weapon, that being a gun here.
By this defendant?
Yes.
We have evidence that this defendant was the shooter?
I would submit that the evidence did suggest that, Justice Johnson, because the evidence from the defendant's girlfriend, whom he was living with at the time, was that the defendant had kept his gun there and had brought a gun to the residence about a week before the Justin Letourneau homicide, which was coincidentally the same time that Alfred Mack was killed. The defendant had the appropriate ammunition for that 22 caliber gun in that apartment that he lived in. The defendant, Tiffany Wellman, his girlfriend, had made statements during trial that the defendant had stored his gun there and had kept it in a closet, and ammunition was kept there. And this
stored the murder weapon. And
right.
We had testimony that was the murder weapon.
The inference was that it was the murder weapon because of the timing, is what the state's position is on that. The evidence was that at some point in time, this defendant and Justin Letourneau had separate guns, and that was during the time of the Alfred Mack homicide, shortly thereafter, up until Justin Letourneau's homicide. But the state would submit the jury had a right to consider the credibility of the evidence, and the state would submit that the evidence did indicate that this defendant was in possession of that gun. And the state would indicate as well that there doesn't have to be any direct eyewitness statement that there was a lack of provocation. I think this court can look to the physical evidence, and the physical evidence in this case was that Mr. Mack's door was kicked in, and Mr. Mack was sitting in his chair, and he was shot either while he was in his chair or coming up off of his chair. There was no disturbance in his apartment, nothing to suggest that there was any provocation that existed in this case. Therefore, the state would submit that those two factors combined would support the jury's verdict of guilty of premeditated first-degree murder.
What way was his chair facing in relation to the door?
I'm sorry?
What way was Mr. Mack's chair facing in relation to the door?
To my recollection, it was facing the door.
Okay, thanks.
Counsel,
Any other questions on that issue before I move on to the next?
I had a question
Yes.
about what I call the gun evidence. There apparently was testimony that the casings from Mr. Mack's apartment and the casings from the car Mr. Smith Parker drove to the ER indicated that both casings were fired from the same gun.
Yes.
Was there testimony that it was the gun used in both shootings?
Yes, that
And-
came from the KBI.
And that was the gun that was attributable by the defendant's girlfriend as being his?
Well, we didn't recover the gun in this case because the defendant admittedly got rid of the gun after he shot Justin Letourneau, telling Justin Letourneau's mother he got rid of the gun because it was involved in something else. So we didn't have the firearm, but we did have the two fired Super X 22 shell cases. One located from Miss Wellman's vehicle that the defendant was driving or had been driving at the time Justin Letourneau was killed, and then the one found inside Mr. Mack's door. And the testimony was that those were fired from the same firearm.
Was there anything recovered from either body?
There was, as to the projectile recovered from Mr. Mack, there was no testimony from my recollection that would indicate or could indicate that it was a .22, but there was in Mr. Letourneau's autopsy. If there are no other questions on that issue, I would move on to the next issue, addressing whether the court erred in consolidating the cases for trial, and the state would submit that these aren't perfectly identical cases, and the state's not making that argument to this court. The state's argument would be, though, that they are the same or similar enough character that the court did not err in consolidating these cases for trial. Unlike some of the other cases in Kansas, as far as the witnesses used in both cases, there were several witnesses that overlapped between these two cases. Obviously, not only did these cases occur 6 days apart, they both involved a homicide with a gun. The gun used in the Mack homicide was the same gun as used in the Letourneau homicide. We had overlapping testimony from Justin Letourneau's girlfriend, Kendra Yannick Ducharme. We had overlapping testimony from Tiffany Wellman, the defendant's girlfriend. We had overlapping testimony from Kendra Jenkins, Mr. Thomas Jenkins' girlfriend, and these cases were sufficiently similar in nature and tied together by some of this common evidence that it would have made no sense to try the cases separately. And the state would submit there could have been an issue trying the cases separately because we would be using some of the same evidence to convict the defendant in Mr. Mack's death as we would in Justin Letourneau's death. And the state's...
Can you explain what that would be?
Well, the fired cartridges. That is what really...
Why did you need to show the... Explain that to me.
Show
because there was no dispute, was there, that the defendant and the victim were the only two people in the car?
On that occasion when Mr. Letourneau was killed, right. No. There was no dispute as to that, but it did...
It went the other way.
It went, yes. It would indicate the defendant's identity with regard to Alfred Mack's homicide. And there was, testimony that the defendant had been with Justin Letourneau and Thomas Jenkins the evening and hours prior to Alfred Mack's homicide, but the state submits that the gun really tied those two things together because that was the the state submits it was the same gun without having the gun. I don't want to say that 100%, but certainly the fired shell cases were the same. They were fired from the same firearm. That Tiffany Wellman, while not identifying the specific firearm, did say the defendant kept at her residence, and of course ammunition matching the same fired ammunition was found.
Do you agree that there's no motivation nexus between the two crimes that was mentioned earlier?
Well, there was some testimony and evidence presented during the trial that after Alfred Mack was killed, Justin Letourneau started talking with some people about that homicide, and specifically the party that they attended prior to Justin Letourneau's homicide. There was some reference made to the Mack homicide, and after that point, the evidence did indicate that the defendant and Thomas Jenkins, the third person involved in the Alfred Mack homicide, started having telephone contact in the hours prior to Justin Letourneau's death. So there was some mention of that and some suggestion that the defendant and Thomas Jenkins had been discussing some of the things that had happened at that party, specifically the comments that Justin Letourneau was making to people that Alfred Mack had been killed and they were involved in it.
In other words, it could be a shut him up kind of process.
Right.
Your point that the state could have had problems if they were not joined is a compulsory joinder worry, right?
I'm sorry?
Compulsory joinder rule worry?
Yes.
Okay, that's what I thought you meant, but I just wanted to be explicit. Okay, thank you.
Yes. Are there other questions on this issue? If not, I'll move on to the next issue. The state would submit the reason as to the hearsay statements of Justin Letourneau that the defense tried to elicit from Kendra Yannick Ducharme. The state would submit that the court's ruling on that, or the reason for the ruling, was not correct. However, if this court finds that that was an error for the court not to admit that statement, if this court finds that it was not made for the truth of the matter asserted, the state would still submit that there's no reversible error with regard to this issue. There was some testimony that after Alfred Mack's homicide, Justin Letourneau had gotten a little more careless and some of his behavior changed. However, I guess the state's point would be that several witnesses testified Justin Letourneau was not suicidal. In fact, his mother testified to that, his sister testified to that. Kendra Yannick Ducharme, the same person they want to elicit the supposed suicidal statement from, said Justin Letourneau was
Because
not.
I have a
Right.
question.
Excuse me.
Actually, I think that hurts you on harmlessness. If the state was permitted to put on several witnesses to say he wasn't suicidal or to indicate he wasn't, then isn't it even more critical that the defense is able to put on the evidence that he was?
Well,
that is the defense, right? That he may have been suicidal and that's why he was doing what he was doing with the gun and that's why we had this terrible accident?
Well, I guess that I look at that differently. The defense was able to put on, well, the defendant testified that Justin Letourneau put the gun to his head, and the state knew that they would be presenting that type of evidence.
Right.
And so the state addressed that through other witnesses. One statement from Kendra Yannick Ducharme that she interpreted not to even be a suicidal statement, state would submit that is not enough to create reversible error in this case. There was nothing else to support from the evidence. There was nothing to support that suggestion that Justin Letourneau was suicidal. So the state doesn't see that as a critical part of the defendant's defense in this case, because the defendant even acknowledged Justin Letourneau was not suicidal. The defendant's position really was the fact that Justin put the gun up to his head and wouldn't take it down when the defendant told him stop doing that. That was the defendant's position at trial.
Messing around.
Yes, and that he tried to pull the gun away from Justin's head and the gun discharged. That was really what the defendant testified to in their position at trial. And so the state submits that in light of that, it would not create any type of reversible error. Are there any other questions on that issue? If not, I'll move on to the next issue, and that is the instruction that worded the instruction to the jury as that the jury will enter a verdict of guilty as opposed to should enter a verdict of guilty. The state submits that there was an objection to that instruction, and state doesn't see how that would have changed the outcome of this case, and the state really has no further argument on that point.
If you don't mind, let me back you up.
No, not at all.
Maybe just a little slow today. On the testimony about whether there was just horsing around with the gun when Letourneau put it to his head, why did you have any witnesses testifying about suicide?
From my recollection, I think it was from the opening statement of the defense, but
So defendant's opening statement says something about
Anticipating.
suicide. You pile on some witnesses that say, no, he wasn't suicidal. Defendant says, well, we were just horsing around with a gun and it went to the head. And then the defendant's denied the ability to have the one witness who could come in and give some evidence that might support the argument of suicide. That I have trouble with that on the standard of error,
And Justice Biles,
from your standpoint.
Right. In my recollection of how that came out, and I would just have to defer to the record on this, but there was some suggestion during the course of the trial that Justin Letourneau was suicidal. And I don't know if the defense asked questions of his mother and his sister in cross-examination that we followed up on. I would have to look at the record on that to determine. But the defendant's own statements right after the shooting at the hospital, the shooting of Justin Letourneau, the defendant said, I killed him. When he was asked why, he said because he beat, his words were, he beat his baby's mama, and then he changed that and said, well, he didn't, but, he was basically not treating her well. So those were his first statements to the first person or people that he talked to after he killed Justin Letourneau. And it had nothing to do with suicide.
And those statements came into evidence as a part of your case?
Yes, they did.
Okay.
In addressing the issue with recall of the jury, the state would first point out, because the state does feel this is significant, when the parties addressed this matter in chambers, the defendant was present with his attorney. Well, he wasn't present initially, but initially the defense said right off the bat, this juror needs to be replaced. And I'm trying to recall, I think the defendant was actually present when the defense attorney was the one who suggested the juror needs to be replaced.
But doesn't that kind of misdirect our attention?
Well,
I mean,
it doesn't.
We're really
it doesn't.
talking about recalling later, not about
We are,
what
but
happened then.
the defense attorney had the ability to insist that we voir dire that juror before that juror was released. And everyone agreed that the juror would not be spoken to in chambers. The defense agreed to that. So I guess if there was any concern about juror misconduct that had led us to that point,
There wasn't any reason for it at that point. That's the problem. It's kind of a
Well-
harsh standard to hold defense counsel to being, clairvoyant about a letter that's going to be sent several.
well,
days
the
or
note
months
did
later.
say they wanted to kick the juror off, which
Because
could
of the language problem.
Right.
Which was consistent with what they would have I'm just talking about the universe of information available to all parties at that point. And so it's not your average preservation problem, really. It's not it's not an exact invited error situation because of that.
Well, I do think it is, should be part of the court's consideration, maybe in combination with the evidence that was presented through form of affidavit from the presiding juror. The presiding juror was very clear that the issue with this juror had nothing to do with the juror's position in the case. In fact, the presiding juror indicated that they really could not even engage in deliberations because it was at such a standstill because of this juror's difficulty with understanding the instructions. And during voir dire, the juror did indicate that there would be some difficulties. In fact, the court told them that there would be some terms that they would use that would not be ordinary day-to-day words. Would that be an issue for you? And the potential juror at that point responded, it would be an issue for you. not for me, but it would be an issue for you.
But the difficulty in understanding the instructions could also be interpreted as a difficulty, and he's not agreeing with us.
Well, and that's where...
I mean, that's the problem with not bringing it back, and this is an interest that the defense and the state has in this particular case.
Right. Well, the juror who was removed also said in his affidavit that he felt like he was removed because of his position in each case, which was directly controverted by the statement of the presiding juror. The presiding juror said, "We really didn't accomplish anything, and as far as Justin Letourneau's case was concerned, we hadn't even started discussing that." So the state's position in that regard would be that the evidence, there was no evidence to support jury misconduct. When the court looked at the affidavit of the juror who was removed with the affidavit of the presiding juror, the state submits that it was clear there was no juror misconduct. The presiding juror was very clear in his affidavit that the problem had nothing to do with the juror who was removed, his position on the case. The conflict was the fact that they couldn't accomplish anything in deliberations because the juror didn't understand some of the simple, even the simple ordinary words. And the juror suggested, "Well, if you think I don't understand the instructions, you can ask the court to remove me." And that's what they did.
Would you agree that it was error for the court to tell the reconstructed jury with the alternate to continue deliberations when we know that at least they had already deliberated Mack because the affidavit says they hadn't even started on Letourneau?
Right. I do.
And so we have, as I towed them up here, because we have a cumulative error issue raised,
Yes.
that we have potentially an error in excluding a statement if we find that it was relevant to the theory of defense. We have an error in saying they will convict. That you agree that was incorrect. You argued it was harmless. And then we have an error in telling the jury how to proceed after they replaced the juror. So we have three errors, so that would fit within the cumulative error paradigm. Tell us why it's not cumulative error.
The state would submit that it didn't substantially prejudice the defendant's right to a fair trial. It did not deny his right to a fair trial. With regard to the failure to instruct the jury to begin deliberations anew, the presiding juror said they did start deliberations all over again. Now, it was very similar to the Stafford case. The court didn't use the word begin anew. The court in this case said continue. The court in the Stafford case said resume deliberations. It was very different than the State versus Cheek case where there wasn't any instruction at all. And the state would submit, in this case, it was not reversible error with the instruction because the jury did exactly what the court should have told them to do. The jury started deliberating anew with the inclusion of the alternate juror.
Any further presentation?
There is none from the state. If there aren't any other questions from this court, the state would simply ask this court to affirm the defendant's convictions. Thank you.
Any more questions? Thank you, counsel.
Sorry. Thank you.
You reserve 4 minutes for rebuttal.
May it please the court. I do just want to touch on the handguns and their possession. I believe the evidence at trial was that Mr. Letourneau and Mr. Smith Parker collectively possessed a .22 and a .357 handgun, and that they interchanged those, basically traded them regularly.
What do you mean? They exchanged use? One would use the .357, the other .22, and then they'd swap use?
They
Know what
would
you mean?
swap them back and forth routinely,
Between them.
the 22 and the 357.
So not necessarily use, but at least possession.
Pardon me, Your Honor?
We maybe don't have evidence that on each swap they were used, but we do have evidence that they changed possession.
Sorry, change possession, not used as in fired.
And the
But-
ammunition that was found in Smith Parker's residence, there were two kinds, were there not? There were the 22 caliber and then 38 caliber.
Your Honor, I couldn't answer that without the record in front of me.
And my recollection was even in the car where the shooting took place, there were some 38 caliber rounds underneath the seat.
I would
So-
defer to this court's recollection. The other thing that I wanted to touch on rebuttal would be the procedure that the consolidation of these cases went through. Defense counsel filed a motion to sever. Initially, the district court granted that motion. When the district court granted that motion, it reached the conclusion, and I'm quoting from the district court, the only thing the court can find is that ballistically the weapon is tied together in these particular instances. The only thing that ties this matter together is the weapon, the ballistics testing on that weapon. So after the district court heard preliminary evidence, it determined that the only thing that tied these two cases together was the similar weapon. Subsequently, after the state raised double jeopardy concerns that it had, the district court essentially reversed itself. But again, we have a finding by the district court following preliminary hearing that the only thing that tied these two cases together was was the fact that the weapons were in common. And I think that in and of itself is clearly insufficient to warrant the consolidation of cases. Unless this court has any further questions.
I have one. On the issue of harmlessness for the hearsay Crawford testimony on the suicide, how do you deal with the state's evidence that Officer Guile testified that the defendant admitted killing the victim when they were at the hospital?
Your Honor,
It seems like pretty good evidence that contradicts your suicide theory.
Your Honor, it certainly was evidence that was favorable to the state. I wouldn't deny that. But the actual statement made was, I believe, I killed him. And that's not totally irreconcilable with the defendant's testimony that he batted the gun away from Mr. Letourneau, and that when he batted the gun away, it caused the gun to discharge. So, in a sense, Mr. Smith Parker, by his own testimony, did kill Mr. Letourneau, but he did not do so intentionally.
Was that argument made to the jury?
I don't believe it was made in closing, Your Honor. I would also note that this comments that the testimony that this was an accidental death was not developed for the first time at trial. Very quickly after this incident, Mr. Smith Parker was interviewed by his parole officer, and he informed his parole officer that the shooting had been accidental. Unless this court has any further questions, I would submit on the brief.
I see none. Thank you, counsel. We thank you both for your arguments this morning. Court will take this matter under advisement.